Welcome to today's program titled Guidance on State and Local Paid Sick Leave Laws, Part 10, What's New with Paid Sick Leave in 2023. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Josh Seidman. Josh, please go ahead.
Great. Thank you, Kate. Hi, everyone. Good afternoon. Good morning. Thank you so much for joining us today for part 10 of our ongoing Paid Sick Leave Laws webinar series. We have a ton of information to present to you on what's been happening in the paid sick leave space during the first 6 months of 2023. So I'm going to jump right in. Joining me today are my wonderful colleagues and friends, Marlon Duro-Martinez, Elizabeth Levy, and Sarah Fowler. I'm Joshua Seidman. If we can go to our agenda slide, you'll see the scope of what we're going to be covering. We're going to start off with a nationwide overview of both general paid sick leave, paid time off, and COVID paid leave laws. We'll then turn it over to Sarah to talk a little bit about the new and probably biggest splash of 2023, which is the Illinois PTO law. Marlon and I will then tackle the updates in Minnesota, which is probably a close second to Illinois as far as the statewide paid sick leave law that was recently enacted in Minnesota, as well as some local developments, most notably in Bloomington. Elizabeth will then cover California and all the going-ons there with both general paid sick leave as well as COVID paid leave updates. I'll then spend a couple of minutes in Colorado talking about recent amendments to that law, as well as updates on public health emergency leave in the state. Sarah's going to then cover updates on Michigan. Marlon will then go all the way out east to New York to cover what's happening in New York with both general paid sick leave, its multiple COVID paid leave mandates that are still on the books, as well as some recent developments earlier this year. And then we'll wrap up with a quick outlook on where things might be heading the second half of 2023 and into 2024. So with that, we're going to jump right in. For starters, with our nationwide overview. As you'll see on this next slide, if you've joined us for any of the first 9 parts of this webinar series, this slide will look familiar to you. It shows the scope of the paid sick leave world. Now, the paid sick leave world has a lot of tentacles, a lot of moving parts. The floor is always moving and shifting on us. The laws that are generally covered in this space are paid sick leave laws and ordinances, paid sick and safe time laws, safe time only laws that are paid. We have public health emergency leave laws, mandatory PTO laws, and any remaining COVID paid leave laws. So that's the universe that we're sort of talking about. Now, as far as the number of active laws, at the end of 2020, when COVID was really up and running, full head of steam, we had nearly 70 total of these laws around the country. Today, mid-June of 2023, we're down by about 10. We have nearly 60 total of these paid sick leave, PTO, COVID paid leave laws. Why the change? Well, a number of COVID leave laws have come and gone. Plenty of these laws have had sunset dates. A number of them popped on the scene for just a number of months, maybe a quarter or so, and then they sunset. So that number has been ebbing and flowing, constantly in a state of flux for the better part of the last 3+ years. And this landscape, even before COVID, was already volatile. If you look at the three rightmost columns, you'll see at the federal level, we still have Executive Order 13706 that provides paid sick leave for many workers of certain federal contractors and subcontractors. This is a really important law to keep in mind, not only if you are a federal contractor or subcontractor, and to the extent you have a covered contract, but also for a point that we're going to cover at the very end of today's presentation during our Outlook section about a federal paid sick leave proposal that was just introduced last month. At the state level, you'll see there are 19 states plus Washington, D.C. Again, Illinois and Minnesota being the two sort of biggest, newest kids on the block in this space. But this list is getting, quite frankly, quite lengthy, quite long. We're running out of room in this column. But you have your 19 states plus DC. And during COVID, over the last 2-3 years, we've seen not just Illinois and Minnesota join this list, but also places like Maine, Nevada, Colorado, New York, New Mexico also join with their statewide mandates. There are, in addition to the paid sick leave laws, more than 24 municipalities with paid leave mandates. That's what makes paid sick leave so much fun to cover. Not only do you have a number of statewide mandates, but also localities, both in states with statewide mandates and more broadly passing these laws. Finally, before we move off of this slide, you'll notice that while we have the 25 municipalities, the 19 states plus DC, and Executive Order 13706 that gives us in the mid-40s of total laws, the reason that we have nearly 60 of these laws is because multiple jurisdictions have multiple of these mandates. New York State, for example, as you'll hear from Marlon in a little while, has 3 statewide mandates, a general paid sick leave law and 2 different COVID paid leave mandates. Same type of thing in Los Angeles City. There is a general paid sick leave law and a hotel-specific paid sick leave law, even though the city's COVID paid leave mandate has already sunset. So again, lots of activity, lots of locations with multiple mandates. Next slide, please. In terms of COVID paid leave, just to give you a very quick recap on what's been going on there, COVID paid leave developments impacted a number of types of laws, paid sick and safe time laws, paid time off laws with guidance, paid family medical leave and statutory disability insurance laws saw amendments and tweaks and adjustments like in New York and New Jersey. And we also saw unpaid family medical leave laws undergo amendments like in Washington, D.C. and New Jersey during the 3+ years that the COVID pandemic has been ongoing. Next slide, please. As far as COVID-specific new types of developments, we've seen, and this slide might look familiar to you from some of our COVID-specific segments of this webinar series. There were 4 main groups. We had entirely new emergency non-vaccine COVID leave laws, supplemental emergency leave laws, that's that orange color. New COVID vaccine mandates, that was that blue color. Amendments to existing laws was in green. And then this broad sweeping non-binding guidance released by existing paid sick leave laws in response to COVID. If you go to the next slide, you will see that at the end of 2020, there were 34 locations that had these type of laws. None of that bright blue color yet because the vaccine had not yet been a thing. So you saw mostly the COVID guidance in purple and the new emergency supplemental laws in orange. Next slide, please. Then fast forward a year and a half to June of 2022, we had 41 locations that had had some type of this COVID leave development, whether it was guidance, a new vaccine law, a new emergency supplemental law, or an amendment to an existing law, right? You can see that light blue color that popped on the scene here. A number of locations with strike-throughs, though. So even though 41 locations had developments between the end of 2020 and mid-2022, 14 of those locations had their laws come and go. They were only around for a handful of months. If you go to the next slide, you'll see finally where we're at today. Now, this does not include locations that still have some COVID guidance out there, right? Not binding, not mandatory. COVID guidance that frankly seems to be quite a bit out of date, several months, maybe even a year or 2 old at this point, but is still on the books in a number of locations. Those are not reflected on this slide. What is reflected on this slide are those remaining COVID emergency supplemental paid sick laws, permanent public health emergency leave laws, which we will be covering later on, talking about Colorado and San Francisco in particular. Again, those are permanent, like the Maryland mandate, although the Maryland mandate has an additional wrinkle that it needs a funding source, as well as then existing COVID vaccine mandates. Several of these locations, the New York State vaccine paid leave law, the Philadelphia COVID supplemental paid sick law, the Nevada COVID vaccine law, do have determined sunset dates for later this year. So you'll hear some more about some of these locations as we go forward, but hopefully this list will give a lot of folks sort of a sense of where these mandates do still exist. Again, we're under 10, but they are still out there. And with that, I'm going to turn it over to Sarah to take us into the Illinois PTO law world. Next slide, please.
Thank you, Josh, and we can advance to the next slide. Welcome to Illinois, everyone. As you saw from Josh's overview, starting January 1st of 2024, Illinois will become the third state to enact a paid time off law, following Nevada and Maine. It's called the Paid Leave for All Workers Act. Some people are calling it PLAWA as an acronym. I am going to refer to it as the Illinois Paid Leave PTO law, which I like a little bit better. And so we'll start with an overview of the law itself. For those of you who are familiar with Chicago and Cook County's paid sick leave ordinances, though, you'll see many similar features between those ordinances and the Illinois PTO law. In terms of coverage, covers virtually all employees. It excludes certain student workers. If they're employees under the Railway Labor Act or the Railway Uninsurance Act, those are excluded. Covers nearly all employers. School districts are a notable exception. Employees are entitled to 40 hours of leave in a 12-month period. That time can be accrued or front-loaded. If it's accrued, as is typical with other paid sick leave laws, we have to carry over. The accrual rate is the same as it is for Chicago and Cook County. It's 1 hour for every 40 hours worked. If you front-load, you can avoid carryover and can require that employees use that time and it wipes clean at the end of the year, starts fresh the next year. And you can limit use to 40 hours per year. So if you're doing the accrual and carryover method, you can still limit the amount of time that employees actually use to 40 hours per year. In terms of increments of use, the Act states that employers can set reasonable minimum increments, which they say is no more than 2 hours of leave at a time. And that's different from Chicago's paid sick leave ordinance. Next slide, please. The reasons for leave, well, this is one place where we differ from paid sick leave. The leave can be used for any reason, and the Act is very clear that employers cannot ask employees to provide a reason for their time off. We can't ask for any certification or any documentation for the time off. So that is a big distinction for this time off law as opposed to our regular paid sick leave laws that we're accustomed to. Employees can choose whether they want to use the leave provided under this Act before using any other leave that may be provided under employers' policies as well. Rate of pay is our standard hourly rate or its minimum wage for employees who are typically paid through gratuity or commissions. For a waiting period, we have a 90-day waiting period for use after hire or 90 days after the Act's effective date. So as a practical matter, even though this Act goes into effect on January 1st of 2024, and the leave needs to begin accruing as of that date or be front-loaded, employees don't actually have a legal right to use that time off until March 31st of 2024. And so similarly, another thing to keep in mind is if you have employees who start working later in a calendar year, like October or later, those employees will not actually have a legal right to use that time off until the following calendar year if you follow that 90-day waiting period after hire. The Act states that employers can institute reasonable notice requirements. They say that that's 7 days for foreseeable time off and as soon as practicable for unforeseeable time off. That's also fairly typical and in line with paid sick leave laws. It does say that if employers are going to have a notice requirement for unforeseeable time off, that needs to be included in a written policy, and employers need to specify how that notice needs to be provided. Next slide, please. Now, one interesting feature about this for Illinois folks is that the time off provided under the Illinois PTO law does not need to be paid upon separation. And again, that is similar to how we typically see payment upon separation for paid sick leave laws. But for those of you who are familiar with Illinois law, typically any PTO or vacation must be paid on separation in Illinois. So this is an interesting and notable distinction, but we have the quote right here up on the slide that you can see. There hasn't been a lot of guidance on this point, and because the Act says that you can use existing time off policies in certain situations to cover the requirements under this Act, we would certainly recommend caution and further discussion with legal counsel before changing any payout upon separation terms if you're using existing time off policies to make sure that those requirements for non-Illinois PTO leave are still being adhered to, because the Act does state that otherwise the regular traditional rules will apply. If you have employees who separate and then return to employment within 12 months, that time off that's unused but accrued will need to be reinstated. The Act does have certain exceptions for collective bargaining agreements, similar to the Chicago paid sick leave ordinance. This does not affect CBAs that are in effect as of January 1st, 2024, but for CBAs that are renewed or entered into after that date, provisions of the Illinois PTO law can be waived, but it has to be done so through an explicit waiver. It also has some carve-outs for construction employees who are covered by CBAs. We have record-keeping requirements for this Act, but it doesn't have an affirmative requirement to provide a balance of PTO to employees with pay stubs the way we do in other locations. We do have to provide that information to employees upon their request. And there is a poster requirement, and for employers who have handbooks, there needs to be a written policy included in their handbook as well. And I just want to call out the anti-retaliation provision, which is similar to what we have in the paid sick leave laws as well, but we're not used to that necessarily in the PTO context. So if we're using vacation or other leave to satisfy the requirements here, we want to make sure that managers and HR folks are mindful of that we don't want there to be any question about taking adverse action or retaliating against employees for exercising their rights to use this PTO. Next slide, please. In terms of enforcement, we have a 3-year statute of limitations under the Act. It's going to be administered by the Illinois Department of Labor. Notably, there is no private right of action. So while we do want to be cognizant of employees bringing claims, they're at least not bringing individual lawsuits in court, but they can make complaints to EIDL that will need to be investigated. And you can see here that there are some statutory penalties and damages that can be recovered for violations. Next slide, please. Formulating a compliance strategy. So the biggest question that we're seeing and working with clients already on is, do I need a new leave policy? Because many of our clients, of course, already provide certain amounts of leave, whether it's through paid sick leave, vacation, what have you, of 40 hours or more. So do we need to create an entirely new bucket of leave? Well, the Act says, yes, an employer who provides any type of paid leave already that satisfies the minimum amount of leave required, 40 hours, is not required to modify their policy if that policy offers the employee the option at the employee's discretion to take the paid leave for any reason. So you could see in the color coordinating what those 3 key provisions are in assessing this. The minimum amount of leave at the employee's discretion to take for any reason. And so when we're looking at our existing leave policies and whether those will work with the Act, those are the questions we want to answer. A lot of what we're seeing in starting to look through clients' policies and determine what revisions may need to be made, we need to look at whether all employees are covered, because they pretty much are under this ordinance. So if we have leave policies that are excluding part-time employees, for example, they need to be brought into the fold and have a policy that covers them. Seasonal workers may also need to be added to this. They may not have an entitlement to use the time off if they're not working past that 90-day wait period, but technically they would still be covered. Do we allow the time off to be used for any reason? Your paid sick leave policies will typically say that time off can only be taken for those paid sick leave reasons. So that may need to be adjusted if we're going to use that for compliance. And then the big one is, does the policy allow time off to be used at the employee's discretion? Because a lot of times our vacation or PTO policies may have provisions that require notice and approval to management, certain blackout periods, or much longer advance notice requirements like 2 weeks or more, and those are going to need to be adjusted if they're going to be used for compliance with the Illinois PTO law. Next slide, please. We want to think about how our compliance strategy is going to fit in with our other existing paid time off and sick leave policies. Most notably, Chicago and Cook County, if you have locations there, they're exempt from this Illinois law. The law states that employers who are covered by an existing municipal or county paid leave law, including paid sick leave, are not covered here. So in Illinois, that means Chicago and Cook County, who has not opted out of the Cook County ordinance. And you also, of course, want to look at this within the fabric of your existing national policies and decide, are we going to make adjustments to Illinois specifically, or are we going to make changes broadly to have a cohesive time off structure? We want to confirm the payout upon separation question for whatever compliance strategy we come up with and make sure that that's coded properly in advance of 2024. And then leading into the next slide, we also want to look for additional state guidance that may still be forthcoming here. Illinois Department of Labor published their first FAQs last month on May 23rd. They, in general, recite a lot of the information that was already in the Act. We called out a notable one here that just shows as an example some of the differences in verbiage here with that question about using existing employer time off policies. The Act itself says the minimum amount of leave. Here they talk about minimum requirements of the Act. I think we still get to the same answer of it's 40 hours for either of those, but we want to be looking at these closely as we're going through the guidance, and hopefully the additional regulations, FAQs will shed some light on some of our additional questions. They do have this email address on IDOL's website for any questions or comments that come up in advance of this, and hopefully they're listening to employers as they're continuing to come up with those guidance points in advance of 2024. So with that, I am going to hand it off to Marlon.
Thanks very much, Sarah. So Josh and I will now be talking about the paid sick leave landscape in Minnesota. So if we go over to the next slide, you'll get a sense of the laws that are out there in Minnesota. The newest sick leave law is the statewide Minnesota paid sick leave law, which takes effect on January 1st, 2024. It will be joining 4 local laws in Minnesota, which includes the newest local law, the Bloomington, Minnesota paid sick leave law, which was enacted in June 2022, amended in January 2023, and it goes into effect in just 11 days on July 1st. There are 3 other laws that are currently in effect in Minnesota. Minneapolis and St. Paul have both been around since 2017, and Duluth joined those laws in 2020. So with 4 local paid sick leave laws, Minnesota is the second state with the most local paid sick leave laws, only second to California, which has 10 local sick leave laws. So it still has a long way to go, but maybe it's going to catch up to California soon. And we're going to talk about the Minnesota statewide law as well as the Bloomington law in detail today. You'll see that there are many similarities between the laws, but there are also some key differences that we're going to discuss. And with that, we're going to go over to the next slide. So as I mentioned, the Minnesota statewide law goes into effect on January 1st of 2024, so there is some time to get in compliance with it. In terms of employer coverage, the law is very broad. It essentially covers all private employers with 1 or more employees. And as you'll see, the employee eligibility standard is also pretty low. It covers any employee who works at least 80 hours in a year in the state of Minnesota, and it includes temporary and part-time workers. However, it does exclude independent contractors, as well as certain air carrier and flight deck or crew cabin members if certain conditions are met. So in the next slide, we're going to now jump over to Bloomington just to see how that compares to the statewide law. As I mentioned, this goes into effect a lot sooner, so there's only 11 days to get in compliance before this law goes into effect. The employer coverage standard you'll see is exactly the same, and it applies to employers with 1 or more employees. However, in terms of eligibility, the standard is very similar, but it requires that the 80 hours that the employee works in the year are within the geographic boundaries of the city of Bloomington. So if you have an employee that works in multiple cities, once they've worked 80 hours in a given year in Bloomington, they would be covered under the law. Also, the law requires that employers let employees use paid sick leave for the time that they work in Bloomington. So if they're working in another jurisdiction where there is no sick leave and the employee requests to use Bloomington sick leave, you don't have to let them use it, but you can. Just like the statewide law, the law includes temporary and part-time workers, and excludes independent contractors. In addition to that, student interns are not covered under the Bloomington paid sick leave law. So next slide, please. So once you've determined that you're a covered employer and you have eligible employees, those eligible employees have to start accruing sick leave for existing employees on the effective date of the law, or for those hired after the effective date of the law upon commencement of employment. The accrual rate under the law is very common amongst what we see in other sick leave laws. The rate is at 1 hour for every 30 hours worked. What we don't see typically amongst most paid sick leave laws, but Minnesota is certainly not unique in this regard, is that it has two different accrual caps: an annual accrual cap of 48 hours and a point-in-time accrual cap of 80 hours. So these two work in tandem. So essentially, every year you can cap the amount of time that employees accrue within that year to 48 hours, and at any given point in time, you can cap accrual at 80 hours, so that would be the maximum amount that the employee can have in their sick leave bank. So although there is no carryover provision specifically in the law, because of this point in time cap, you can most likely cap the carryover at 80 hours. In terms of usage cap, it's unclear because there's no usage cap stated in the law, but most likely that was intentional. As we'll see in Bloomington, there's also no usage cap there. However, what is very different about the state law from all the local laws in Minnesota is that there is no usage waiting period. This is unique in Minnesota for there to not be a usage waiting period. However, many of the recently enacted paid sick leave laws do not have usage waiting caps, so it's not unique in the broader paid sick leave landscape. So these provisions actually make Minnesota one of the most generous all statewide paid sick leave laws in the country. So next slide, we see that Bloomington, the start of accrual, accrual rate, accrual cap are all the same. The carryover cap in Bloomington is clear, it's 80 hours. No usage cap, just like in Minnesota, but there is a 90-day usage waiting period there, so that is different from the statewide law. Next slide, please. So for those of you wondering if instead of allowing accrual, if you could front load, the answer is yes. Instead of accruing, you could provide employees on the first year with 48 hours of paid sick leave. And then in year 2 and subsequent years, you have two options. One option would be to front load 48 hours, but pay out the time. And that way you eliminate year-end carryover. Or option 2 would be to front load 80 hours at the beginning of the second and subsequent years. And that will likely eliminate year-end carryover and cash out obligations. For those of you with a union workforce, you cannot, there's no exemption for CBAs, so you can't use a CBA and exempt yourself for compliance with the law. You would still have to comply with the law. Payment of sick leave is employees have to be paid at the same hourly rate as the employee normally earns, but not less than the minimum wage. Time increment limitation. So there's actually a difference between the statewide and Bloomington law here. In Bloomington, you have to use the smaller of either 4-hour increments or the smallest increments of time tracked by the employer's payroll system. So if your payroll tracks time, say in 6-minute increments, you'd have to allow employees to use time in that level of increment. And if we go over to the next slide, we're going to see that that is different in Bloomington, because if you have a policy or practice of having an increment of use that is 4 hours or less, you can use that increment. So you don't have to allow employees to use leave in the smallest increment that your payroll requires. You can just set a policy that employees can use sick leave in 4-hour increments. In terms of front loading, this is similar to the Minnesota law, but not quite the same. There's no two options. You only have one option of providing employees 48 hours on year 1 and then front-loading 80 hours on year 2 and subsequent years to get rid of carryover. CBAs, just like in Minnesota State, you have to comply with the law. There's no exemption. And for payment, the only difference I want you to be aware of is that employers with less than 5 employees can provide unpaid leave, whereas those with 5 or more employees can provide paid leave. And with that, I will turn it over to Josh.
Wonderful. Thank you, Marlon. Next slide, please. So now that we've heard about coverage and eligibility, accrual, usage, front-loading, carryover, let's talk about what the paid sick leave under the Minnesota and Bloomington laws can be used for. You can see on this slide we have a lot of very common covered absences, the employee or family member's health condition-related absences, including preventative care, safe time absences where the worker or family member are a victim of domestic abuse, sexual assault, or stalking, absences related to the employee or the family member having a communicable disease and posing a risk and potential exposure to others in the community. Those are numbers 4 and 5 on this list. And then number 3, which is sort of an interesting wrinkle, closures of the worker's place of business or family member's school or place of care, not only due to public emergencies, but also due to weather. And that weather component, while it does exist under some of the local laws that are already out there in Minnesota, that is an outlier as far as the rest of the country and covered reasons goes. If we look on the next slide how this compares to Bloomington, generally the covered reasons overlap, sick leave, safe time, those type of absences. However, there are a few wrinkles between Bloomington and Minnesota and the covered reasons. I'm going to point out just one of them here, notably while the Bloomington law itself covers absences, you can see here that example, closures of the family member's school or place of care, not only due to inclement weather, but also due to loss of power, heating, water, or other unexpected closures. If you remember from the prior slide, the Minnesota state law only covered weather-related closures. So a bit of a wrinkle where Bloomington is broader than the Minnesota state law. There are a couple of examples of how the Minnesota state law and its covered reasons are broader than the Bloomington law as well. Most notably that absences for closures of the employee's own business for weather-related events and occurrences is not covered under Bloomington, but it would be covered under the Minnesota state law. So that's another wrinkle of how Minnesota's law would be more broad than the Bloomington covered reasons. As far as covered family members, you can see the list of Bloomington covered categories here, the most notable one being members of the employee's household. Next slide, please. Looking at the scope of covered family members from the Minnesota state law. So in addition to some broad covered reasons, potentially no cap on use, an interesting front-loading component, the no usage waiting period, all the things that Marlon went over, its broad scope of covered family members is another really important wrinkle of this impending statewide law. Not only does it cover a number of the expected categories that we see in other jurisdictions, it has the catch-all that we've grown accustomed to in many paid sick leave locations, the close association who's equivalent of a family member, and also, very importantly, a designated person component where employees can designate one person annually for whom they can use paid sick leave to care for that individual in addition to other identified family members. You can see notice and documentation, pretty common, 7-day notice for foreseeable leave, as soon as practicable notice for unforeseeable leave, with a written policy requirement. If the employer is going to require notice from workers, the policy needs to have the reasonable procedures outlined in it, and that policy must be distributed to employees with a written copy. Documentation, employers can require reasonable documentation once the worker's been out for more than 3 consecutive days. Next slide, please. Notice to the worker, from the worker to the company, and documentation, same as under the state law, as under the Bloomington local law, with that same written policy requirement that I mentioned on the last slide also appearing here in Bloomington. So employers who have operations in Bloomington, that law is coming in 10 days. If you don't have a written policy already developed, now is the time to make that. Next slide, please. Notice and posting, very important topic under the Minnesota state law. You can see that employers are obligated to provide notice to employees by the later of the effective date of the law or upon hire. They can do that through one of 3 ways: post it, give out a hard copy to individual employees, including during onboarding on a going forward basis after January 1st of next year, or posted electronically on a platform where employees will be performing their work. The Minnesota Department of Labor will be preparing that model notice. Employee handbooks, another really important practical point. If you have an employee handbook, the Minnesota state law, like the Minneapolis local law, requires employers to post that forthcoming notice of employee rights and remedies in their handbook. Balance notification, another important topic. The Minnesota state law, when it goes live next year, will require that employers include, among other statutorily obligated topics on earning statements, they now will have to add several topics related to the paid sick leave mandate, including total number of hours accrued, number of hours available for use, and total number of hours used during a pay period. Finally, employers can use PTO or other paid leave policies for compliance with the Minnesota state law, as long as those policies provide leave that can be used for the same purposes under the same conditions and that otherwise meet the minimum threshold standards of the Minnesota state law. There's a record-keeping component. Records need to be maintained for a period of 3 years plus the current calendar year. If you go to the next slide, our last one for Minnesota, you will see very similarly, there is an employee handbook notice obligation where the model notice needs to be posted in employee handbooks. That's again for Bloomington. Similar balance notification standards on the employee pay stub, right? So that will need to be updated if you have operations in Bloomington in the next few weeks. There's a posting obligation as well. There's a model notice that's been released at least in English, and other languages are being prepared for later this month. And then finally, you can use PTO for compliance. The same similar standards need to be satisfied as we mentioned for the Minnesota state law, and there's a similar record-keeping requirement for Bloomington. So Bloomington, you have about 10 days to get everything in order. If you haven't already, certainly worth paying attention to it. Minnesota, we have 6 months and about 10 days to get everything ready there. Lots of activity in the state of Minnesota. I'm going to turn it over to Elizabeth now to take us through California.
That was a lot. I have to say, Minnesota might be giving California a run for its money. Well, I'm sure California will have a response, but we can go ahead and dive in.
I can't wait.
So I'm going to give a very, very fast overview. Hopefully this is all incredibly old news to everyone. California has a paid sick leave law. It's been in place for about 10 years. Really hope that doesn't surprise anybody. It's the statewide law. Covers virtually all employees with a couple exceptions. There's some CBA exceptions. It's complicated. A few guardrails. Employees need to work 30 days a year in California. You can have a 90-day hold on initial use. There's a very broad list of reasons that employees can use this paid sick leave, which is now, as of this year, slightly expanded, which we'll get into. But all the usual things you'd think of, as well as issues arising from any kind of domestic violence, stalking, sexual assault, caring for family members, preventative care. Now there's a bereavement leave in play, which we'll briefly discuss. Employers can't deny the right to use accrued sick days. If people have them, they have to be able to use them. You don't want to get lost in the weeds of denying leave for, reasons that are covered. And there's a rebuttable presumption of unlawful retaliation if there's an adverse action that occurs within 30 days of a protected activity. So adverse action, usually something like termination, demotion, those types of things. We can flip through this really quickly because I know I could spend hours talking about California, but I won't do that to any of you. So just sticking with the statewide leave, high level overview. Hopefully this is all old news, but you can go on an accrual basis or an annual lump sum grant. So you can do an hour per 30 hours worked, can have a cap of accrual at 40 hours, and can limit the amount of paid leave that employees can use in a year to 24 hours or 3 days. If you do the accrual, the balance carries over, or you can do the lump sum grant where you're getting at least 24 hours. In that situation, there's no accruals, no carryovers. We can keep flipping through. So one of the things that makes California paid sick leave kind of incredibly annoying at times are some of the record keeping, tracking, and accrual requirements. So one thing that is very easy to get tripped up on is that it needs to be on the pay stub or a document that's issued contemporaneously the same time as the paycheck. And there's some some guidance and nuance about that, but employees need to know how much paid leave they have available. Employers need to hang on to these records for at least 3 years. If an employee leaves but then comes back within 3 months, you need to reinstate the balance. Seems like a pretty easy thing, but it can be complicated. It got very complicated with all the COVID leaves swirling around. And it's something that you just want to get right, because you get one of those records requests, employees are looking for their pay stubs, it's going to be, it's either there or it's not. So it's something that you want to just make sure you're doing right. We can flip to the next slide. So that you can require that employees take the paid sick leave in increments of at least 2 hours. And something else that's very easy to get tripped up, where this starts to overlap with wage and hour territory, is how employees are paid. So exempt employees, pretty easy. You pay them how they're typically paid for other time off. For non-exempt employees, it can be a little trickier. You can use the regular rate in the leave, or I'm sorry, regular rate in the week that the leave is taken, or you can use this 90-day look back method. This got a little complicated with COVID leaves, but for the regular California statewide paid sick leave, these are the methods of calculation. So again, seems pretty easy, but you want to make sure you're doing it right. You don't want to just be paying people their paid sick leave at the base rate of pay. If there's regular rate, I won't spend hours talking about regular rate. That's its own ball of wax in California, but you just make sure you're doing it right. And we can flip forward to the next slide. So local paid sick leave laws, there are a lot. I guess we're still winning ahead of Minnesota, if you can call it winning, but we wouldn't have time to go through all these. These are not really new for the most part, except there's the new West Hollywood pay time off ordinance that came into effect about a year ago. This is just a heads up for folks. If you have businesses in these jurisdictions, you have businesses doing in certain industries, like the Los Angeles hotel ordinance that was mentioned earlier, just you're going to want to pay attention. You're going to want to make sure that you're in compliance with these local ordinances. And it's tricky because the general rule of thumb is that you need to comply with what is the most stringent, and all of these local ordinances, if you have operations all over California, can sure make it tricky to have a unified statewide policy, let alone a unified nationwide policy. But these are just, things to keep in mind. Some of these have been rattling around for a while, and we don't see them going away anytime soon. But we can flip ahead to the next slide and move on with some of the updates out of California. And I am pleased to report there's some actual good news for a change. I feel like usually I'm just the bearer of bad news, but most COVID paid sick leave is done. We're done. We had a lot. We had so many. It was like playing whack-a-mole. There were so many, and now we are really just stuck with Oakland. So there was the statewide California supplemental paid sick leave that finally expired in December 31st, 2022. That was the third, and I think fingers crossed, final round of that. There is, if there are any small employers or nonprofits on the call, there was some language in the 2022 version of that law that provided some potential relief. I just included a link here in case that applies to any folks to potentially get some relief for California supplemental paid sick leave that may have been paid out. Cal OSHA earnings continuation wasn't really paid sick leave. It was this thing created by Cal OSHA, but you had to pay earnings and benefits as if folks were still at work and hadn't been removed from the workplace. That finally went away in February 2023 when a new Cal OSHA non-emergency standard came into play. There have been some potential rumblings of maybe having the earnings continuation come back in some other form, but I will just, at this point, there's nothing concrete. That can be a something for another day. For the time being, good news, don't have to deal with it. And then some of the holdouts, there was the Los Angeles City and Los Angeles County and Long Beach. Those were some of the last lingering ones that continued on for a while into more recent history. But like I said, Oakland right now, the only local one that we're stuck with, it's tied to the period of emergency. There's no real end date. So if you've got businesses in Oakland, just keep that in mind. But for the most part, we're pretty much in the clear on the COVID paid sick leave front, and we can go ahead and flip to the next slide. All right, the San Francisco Public Health Emergency Leave Ordinance. It's kind of like a cousin of the COVID paid sick leave, certainly I think prompted from the COVID paid sick leave, but it is a new permanent standard, applies to larger employers. There's some carve outs for CBAs and certain types of healthcare workers. The reasons for covered leave are going to be very familiar. It came into place October 2022, right after the San Francisco COVID paid sick leave had expired, but it was, the COVID emergency was still in place, so folks could still use it for COVID reasons. So basically, if you're ordered to quarantine or isolate, seeking a diagnosis, if a healthcare provider advises you to stay home, you're caring for a family member in those circumstances, you have a school or care provider closure, you can take the leave. But the big caveat is that since the COVID emergency is over, you can't use it for COVID anymore. The one area where it still really could be coming into play is where there are air quality alerts. And again, it's very nuanced, but if it applies to you, you're going to want to make sure you're aware of it. If you have folks that are primarily working outside and they're vulnerable, essentially there's some respiratory types of issues. There's specific categories of vulnerable folks who may be primarily working outside that would be able to take leave under this public health emergency. So those folks, if there's a public air emergency or air quality alert, those folks can take leave. Fingers crossed we don't have any new pandemics ever, or at least not for a very, very long time. But if there's some new public state of emergency, for example, there was a monkeypox state of emergency. If there's some new state of emergency, this will kick into play. Like the COVID paid sick leaves, folks can get up to 80 hours a year, prorated for part-time. And like the California statewide leave, you need to put the available balance on the wage statement. So we can go ahead and flip to the next slide. All right, so a few statewide updates. California's statewide paid sick leave that we ran through very quickly a moment ago has a new category for designated person. I think it's interesting. I saw that the Minnesota law had that. I think this must be just, and Josh, I mean, you certainly know, Josh, if this is a national trend that you're seeing, but I think it's interesting that you're seeing the designated person in more and more places. We had this in some local ordinances in California, and now we have it at the statewide level. But basically, it's a person designated by the employee. And California Family Rights Act leave, while it's not a paid sick leave, I just want to briefly mention the fact that now, as of this year, the designated person can also be somebody that CFR leave is taken for. So now you have this, this came into play at the same time, dual tracks in California. If you haven't updated your policies, you may want to do that. But the designated person leave is now in play for both paid sick leave and CFRA. And so we can go ahead and flip to the next slide. So the employee must be allowed to designate the person at the time the request is made. There are some guardrails. So an employee can only designate somebody once a year. You can't, say, okay, I'm taking leave for my cousin, and now a week later I'm taking it for my best friend, and a week later I'm taking it for my dog walker. There are some guardrails, but an employee must be able to designate at the time their request is made. And so we can go ahead and, like I mentioned, good time to update handbooks, policies if they haven't been updated already. We can flip to the next slide. And so bereavement leave, I know I mentioned this briefly up top. This is a new requirement that came into effect in January. Basically, employees can get up to 5 days of bereavement leave upon the death of specific family members. The family member for the bereavement leave purpose is defined as the spouse or child, parent, sibling, grandparent, grandchild, domestic partner, or parent-in-law. The leave doesn't need to be taken all at the same time, but it needs to be taken within 3 months within the date of the death of the family member. And Like I said, sort of notably, if an employee has vacation, personal leave, accrued and available sick leave, or any other kind of compensatory time off, they can use that time towards bereavement leave that would otherwise be unpaid. So a little bit of overlap in the Venn diagram of paid leave space. And employers can require documentation. It's, that is permissible. It's the types of things that you would think of, like a, death certificate, et cetera. I would say, if you're going to request documentation, you want to do it carefully and thoughtfully and consistently. And we can go ahead and flip to the next slide. So looking ahead here, I think, I don't know, maybe California just heard that Minnesota was creeping up and it wanted to make sure it stays at the front of the paid sick leave oddity race. But some proposed legislation that is still, at this point in the legislative cycle, still alive. Some things don't make it this far into June, but there's this SB 616, which would increase the mandatory amount of paid sick leave and the employer's authorized limitation on the use of carryover. So we'd go from 24 hours or 3 days each year to 56 hours or 7 days. And then the accrual thresholds would go from the current 48 hours or 6 days to 112 hours or 14 days. So pretty big potential jump. We'll see if it goes through. We keep track of, we have resources and blogs. We keep track of all of these things. So not just, this paid sick leave oddity, but all the fun new things that may be coming out of California this legislative session. Keep an eye on that if this is something that may impact you. And then just something to note on the potential future of paid sick leave and PAGA penalties. The landscape is, I'll say, just uncertain. And there's a recent Court of Appeals case that did hold that the paid sick leave penalty or paid sick leave violations could form the underlying predicate of certain PAGA claims. It's Court of Appeal, not the Supreme Court. I wouldn't be surprised if we eventually heard more on that issue. Which way it'll eventually go involves reading some tea leaves, I think. But just a reminder that paid sick leave is a particularly important thing to comply with, and making sure that you've got your I's dotted, T's crossed, always a good thing in California. And with that, I will hand it back over to Josh.
Thanks, Elizabeth. So jumping over to Colorado, next slide, please. Two big things that have happened very recently, earlier this month in Colorado. The first one is that the state passed amendments to its covered reasons for use under the general paid sick leave law. In addition to general sickness for the employee or the family member, safe time reasons, certain public health emergency related absences, the state now also, as of August 7th, will include bereavement leave, as well as family member school and place of care closures or evacuation of the employee's place of residence due to certain unexpected occurrences, including things like inclement weather, loss of power, heating, water, or other unexpected occurrences or events. Might sound familiar to you because those last two bullet points certainly sound a lot like what's going on in some of the Minnesota localities, Bloomington most specifically, and the Minnesota state law. Next slide, please. Also, very importantly, and similar as was the case in California, like what Elizabeth said, good news in Colorado, the public health emergency for COVID-related absences is now sunset. That ended on June 8th after more than almost 2.5 years of being around. Now, this is a permanent mandate. So just because there are no COVID-specific public health emergency declarations at the federal, state, or local levels doesn't mean that this mandate will go away. It is on the books, just like jury duty or voting leave in any of these other states that have miscellaneous types of leaves. So keep it in mind. It is very possible that we will hear more from Colorado public health emergency leave when we get into the fall and winter as things like flu, RSV pick back up. And with that, I'm going to pass it over to Sarah to cover a quick update on Michigan.
Thank you, Josh. Next slide here. So you can review this after our presentation for the full history of what's been going on in Michigan in the past year. But the upshot is this. About a year ago, the Michigan Court of Claims ruled that the Michigan legislature's changes to Michigan's ballot initiative that implemented its paid sick leave law was unconstitutional. And what that meant was that Michigan employers were going to need to change their paid sick leave starting in February of 2023. There was a great period of uncertainty. But in January of 2023, the Michigan Court of Appeals reversed that decision. It upheld the Michigan Paid Medical Leave Act that the legislature had put into place. And that decision is now on appeal. So as we can see on the next slide, we still have a little bit of uncertainty in Michigan continuing into 2023, and we'll see how long that lasts as to the state of paid sick leave. For now, we can maintain the status quo, 40 hours of paid sick leave in Michigan, but we are still monitoring this decision, Mothering Justice versus Nessel, to see how the Michigan Supreme Court decides and whether that will necessitate any changes to paid sick leave in Michigan. So it's been a bit of a roller coaster in my home state for a period of time, and we will see how this plays out as the year goes on. I do want to say for our next slide here, we have our CLE code at this time for everyone. It is SS7147. That's SS, as in Seyfarth Shaw, 7147. And I'm going to pass it along back over to Marlon.
Thanks very much, Sarah. So now we're going to be talking about New York. So if we go over to the next slide, I wanted to provide an overview of select New York State laws. So New York has a paid sick leave law, a separate COVID-19 emergency leave law, a separate COVID-19 vaccine leave law, which we'll talk about in a bit, a paid family leave law, as well as temporary cash benefits in addition to a number of unpaid leave laws. But you can look at the details on this later. And we're going to go over to the next slide, which we are going to look at some of the local leave laws in New York. We have New York City that has an Earned Safe and Sick Time Act, as well as a temporary schedule change law that impacts leave. And then in Westchester, we have the Safe Time Leave Law, which is still in effect. It was the Sick Time Act that was preempted by the New York State law, but the Safe Time law is still in effect. And with that, we're going to go over to the next slide to briefly look at some updates in New York City. So there were proposed amendments to the New York City Earned Safe Time rules that were introduced at the end of 2022, and the comment period closed at the end of 2022. Seyfarth actually submitted comments on behalf of our clients highlighting the overly burdensome and unclear rules. However, we still don't have the finalized rules. When the final rules are released, they will address a number of important points, as you'll see on this slide. Employer size, whether it's a nationwide count, which the rules seem to suggest, or just based on how many employees an employer has in New York City. If it goes with a nationwide count, as the rules suggest, this could be burdensome for employers with a small footprint in New York City. Accrual programming will also be impacted. The rules want that employers track it in less than 30-hour increments. But we will see what the final rules will say on this point, because this would require significant adjustment to employers' payroll systems. Rate of pay, the rules actually create an inconsistency between the law's regular rate of pay and the rate in effect standard that the rules have proposed. There are a couple of other things on the next slide that the rules would also impact, specifically for successor employers. They could become liable in an acquisition or transfer for failures of the prior employer to comply with the law and fail to keep appropriate records. Another thing that the rules want to create is a reasonable inference that employers who don't maintain a compliant policy or adequate records, or fail to maintain and distribute an ESST policy to employees, or don't provide leave in accordance with the law, there's a reasonable inference that just doing that means that you are not complying with the law, and that employees will be entitled to a relief of $500 per employee covered by policy per calendar year. For those of you who are familiar with the Fair Work Week law, such reasonable inferences can have penalties rack up pretty quickly. On the next slide, there's some information on the New York State COVID-19 emergency leave law. The main takeaway is just make sure you're staying on top of the CDC guidance, because there are practical limits to the New York COVID 19 emergency leave law due to those to that guidance. So just make sure you're staying on top of that. And then next slide, please. As to the vaccine leave law, I just want you to make sure that you know this is still in effect until the end of this year. It did not expire last year. So make sure you're providing employees with vaccine leave law. And then finally, the next slide, there is a New York anti-retaliation law in effect. So the amendments went into effect on February 19th of 2023. And these make it especially important that you're complying with all leave laws as there are now additional penalties for non-compliance. And with that, I will turn it over to Josh.
Perfect. Next slide, please. So we have a very quick outlook on where things stand. You'll see on the next slide, we have all the big players we spoke about today: Bloomington, Colorado, coming online the next 2 days, the next month and a half, and then Illinois and Minnesota in about 6 months in a week or so. We'll see what happens with the COVID mandates. Next location is likely to adopt. You can see some states, plus always keep in mind the California localities and what they might be up to. But federally, very importantly, last month, the Healthy Families Act was reintroduced. It's Bill S-1664. This bill has been introduced a number of times over the last several years. Very little attention has been paid to it. As we speak, this afternoon, Senator Bernie Sanders will be on the floor of the Senate to discuss this particular piece of legislation in detail. And then tomorrow, Senator Sanders, who's the chairman of the Senate Health, Education, Labor, and Pensions Committee, will be marking up this bill. They just released a press release on this yesterday. So it is interesting, nothing to see yet, but keep a close eye, or a closer eye than you normally might do, because federally, all the attention seems to be on federal paid family medical leave prospects. This paid sick leave bill could be sneaking under the radar for later this year, so something just to keep an eye on. Next slide, please, and then one more after that. Finally, to wrap up, we have a number of valuable resources for you all if keeping up with the paid sick leave patchwork is as daunting for you all as it is for us. We have a premium survey. You can reach out to us for more information on the survey through this email address. We also have a mailing list that you can sign up to get free notes on any legal updates, blog posts, podcasts, webinar invites, and all the like that we release on this topic. So you can sign up at that link below. Next slide. We also have this webinar series, which has covered a ton of ground during its first 10 segments, as well as a Take It or Leave It podcast, where we cover a number of not just paid sick leave, but other leave of absence and accommodation topics. You can get more information about the podcast at the link at the bottom of the page. And then finally, for those of you with operations in California, we have several California-specific resources available to you, including our California Peculiarities ebook that should be coming online very, very soon for our 2023 version. Thank you so much for everyone who submitted questions. We've responded to a number of those throughout the time today. We look forward to seeing everybody at our next presentation. You can go to the last slide and you can see our email addresses here. We'd love to hear from you if you have any feedback or additional questions in the space. Thank you, everyone.